This academic segment, please welcome Professor Eric Zacks from the Wayne State University Law School. Professor Zacks is going to present on the business judgment rule, its application, and how it should be considered at the pleading stage. Once Professor Zacks concludes his presentation, we will have a 25-minute period of dialogue between the professors, and you are very welcome to submit your comments and questions in the chat box. Professor Zacks, take it away.
Well, thank you, and good evening, everyone. Thank you to Mark and the Rossman firm and the co-sponsors. Obviously, I'm happy that Wayne State's involved with this, the Journal of Business Law, which I was involved with as they got started. Really excited, and at this point, I've been out long enough, or I've been in the academy long enough where among the participants, I see more of my current students or former students than I see former partners or colleagues. So I guess that's just a sign, but it's nice to see you all here tonight. So I'm going to try to quickly get to the topic that we're all here for, but I do need to situate what I'm doing because it's part of a larger project. Really, the larger project was just the business judgment rules applications to pleadings generally in the fiduciary duty context, because and again, this project is in its infancy. I became aware a few years ago on two different but related issues concerning the business judgment rule. Because of Iqbal Twombly, does it require substantively different pleadings with respect to the business judgment rule? How does it apply at the federal level? And does the business judgment rule in the first place even apply at the pleading stage? Now, as I was beginning my research, I started talking with Mark, and he asked me to speak. So I sort of, this is sort of a diversion, maybe a little bit of a tangent, and took a pause with that and sort of really considered the business judgment rule with respect to oppression. But to get to the oppression parts, I want to talk about sort of how we get there. Starting with some of the basics, talking about some of the pleading issues, the splits that have come up, and then particularly in the oppression cases in Michigan. So again, the basics, when we're talking about breach of fiduciary duty, the business judgment rule, which everyone hopefully remembers from corporations. I'm looking among the participants to see which of my current students I can test this week, because we're actually covering the business judgment rule this week. But the presumption basically that the directors did their job, right? So they acted in good faith with requisite care, loyally, and all that. And the consequence is that if the plaintiffs cannot rebut it, then the case can get kicked, right? So and one of the issues that comes up is, well, when do we evaluate that, right? So how do we, when we say the directors are entitled to that, when do they get the protection of that? And what I was interested in was looking at, well, do you get the protection of that at the pleadings level, right? So can you, if someone, or again, a motion to dismiss for failure to state a claim, can you get it kicked at that point? And there's, again, two general approaches, and one says yes and one says no, but they can get tested. Again, the business judgment, I sort of put it up here, that you obviously can get tested later, right? So on a summary judgment motion, but I was really focused on more of the earlier stage. And again, this can raise some, on the pleadings themselves, it can raise some interesting questions when the case is brought in federal court. Under the older notice pleading standards, some cases held that the business judgment rule did not apply at the federal level. You had to allow for factual discovery, and you didn't want to preempt claims by imposing some sort of pleading with particularity requirements, including the application of the business judgment rule. So the business judgment rule is providing you with this protection, this presumption. It might have been more difficult to overcome it if you were going to apply that standard, and maybe it wasn't appropriate if you're applying the federal notice pleading standards. Now, again, some of those decisions, that the most, I think, famous of which is Tower Air, came out before Iqbal and Twombly, which imposed the plausibility requirements, the heightened standards for federal court pleading. And it's really unclear of those impacts on the more broad Tower Air holding, that the business judgment rule isn't really, it doesn't need to be, doesn't apply at the federal level. Now, there's cases out there since Tower Air among the different circuits that say the federal pleading standards do require a plaintiff to overcome the state's statutory business judgment rule. And still other courts, though, whether or not they discuss Tower error, and sometimes without discussing the impact of the federal pleading standards, they just decide the business judgment rule is not appropriate at the pleading stage, regardless of the pleading standards used. So that takes us to Michigan. And without addressing sort of, again, the split of authority that exists elsewhere, which is, again, sort of my larger project, Michigan courts have typically held that a party must plead sufficient facts to overcome the business judgment rule and survive a summary disposition for failure to state a claim. So if you look back at, again, I guess 18 years ago, the Torella case, and this is a common fact pattern, by the way, in a lot of these breach of fiduciary duty as well as oppression claims, but these failure to pay dividends. The policyholders of an insurance company brought suit against the company and the directors, seeking to compel them to pay, to distribute out of the excess surplus. And on appeal, the Michigan Court of Appeals upheld the trials court decision, holding that the policyholders did not have a right to compel distribution of a surplus where they did not sufficiently plead facts to overcome the business judgment rule. So in order to determine that a claim was legally sufficient, the court would have to decide that the policyholders were not precluded by the business judgment rule from bringing suit. But because they did not explain how the directors' failure to consider distribution constituted fraud or bad faith dealings, because they didn't cite any cases to that point, they found that they did not sufficiently plead facts that would overcome the business judgment rule. And that's been reiterated in a few holdings, a couple unpublished decisions since, and at least one federal court in Michigan has followed Michigan law in requiring a party to plead sufficient facts to overcome the business judgment rule. And that's the CMH liquidating trust case, where a liquidating trust filed an adversary proceeding against a hospital's former officers and directors alleging breaches of fiduciary duties, and they responded by filing a motion to dismiss because they didn't plead sufficient facts to overcome the business judgment rule. Now, the court ultimately found that they had pleaded sufficient facts, but they did say that the business judgment rule does apply here. The plaintiff must plead sufficient facts to overcome the business judgment rule. And the court took notice in a footnote that there is a split, right? That there's a split in other jurisdictions where you shouldn't have to plead sufficient facts, or it's a question of facts where the business judgment rule is not applicable at the pleading stage. So in summary, and again, I went through that I hopefully relatively quickly, just to say that you should be aware, obviously, of the business judgment rule pleading issue, depending on the court that you're in, again, and also whether or not you're at the state or federal level. And this has obvious ramifications for oppression cases if the business judgment rule applies there in the first place. All right, so let's go to relevance to oppression. So it could come up in just a summary judgment case, and I'll get to the Franks case in a minute. But just to say that some states do not use the business judgment rule in oppression cases. They just say it's not applicable, it's not relevant. There's a number of theorists out there. I think Professor Moll has written on this, that it may not be appropriate to consider whether or not a business judgment or decision, that the process by which it was made, maybe that's not really relevant when we're trying to test the minority's expectations of whether or not they were frustrated. So another number of states have rejected. I think New York and New Jersey, Massachusetts, there's some others have said business judgment rule oppression cases, not relevant. So that obviously has implications for pleadings and for summary judgments as well. Now in Franks, the business judgment rule was held to apply, and I'll explain how I get there in a second, but it should be remembered it was a C8 and C10 in motion, and the decision largely dealt with the summary judgment, what I'm going to call the summary judgment aspects of it. And it said that, look, they provided evidence demonstrating, and if you demonstrate acts that are inherently wrongful, that necessarily means you overcame the business judgment rule. So if you present evidence that decisions were not taken for legitimate business reasons, but instead to oppress the shareholders, then you can overcome the business judgment rule and survive motion for summary disposition. Now, and again, in some cases, there's some other cases out there, this proposition hasn't really been tested. It's not, the business judgment rule hasn't been raised every time. So now, Frank's was interesting for a couple of different points. One, it wasn't clear to some upfront whether or not the business judgment rule was actually doing any work here, whether or not it was actually applied. And some have argued that the court, that it actually does not apply. They were just saying, look, all you have to do is plead sufficient to get to oppression. And if you do that, which you have to do anyway, you've overcome the business judgment rule. But there have been decisions that have suggested that, and again, this is a 2020 case, that the business judgment rule does apply, right? So it is relevant in some way. The court was just saying in Frank's, at least according, on this decision, was saying that, well, we have to look at it, right? So we have to see whether or not you overcome the business judgment rule. And hey, if you do plead facts, it's going to overcome the business judgment rule. You may still counter that. That's not doing much work. But I think, and again, we'll return to this at the end, but I think if you couple with the limitations in the oppression statute that Professor Moll was talking about, and some of the other things here, I think there is some work that the business judgment rule can do from a defensive posture. So again, at least in this instance, you had it is relevant. Now in other states, just to give you a flavor, again, these and all these that I'm showing you, I'm gonna get to a pleadings case in just a minute, but just to show you how these end up playing out. If you plead sufficient facts to put it in question whether or not the business judgment rule applies, or whether or not you rebutted the business judgment rule, you're going to survive, right? So that's the idea. You at least on summary. So this was a Missouri case that both parties agreed on the facts. They just couldn't agree on the characterization of the facts. Okay, fine. Well, that case is not going to be dismissed. Now, if you don't, though, there's a couple other cases on point. So another Missouri case said, look, you just said that the valuation method that the board used to value shares was not good. That's not enough. And again, these are on summary judgment. These weren't on failure to state a claim, which I will get to that in a minute. But again, you can see where if you don't plead sufficient fact, if you don't show enough evidence, you might lose on summary judgment because of the business judgment rule. So business judgment rule might have teeth at summary judgment, might have teeth at the pleading stage. And then in Texas, went so far as to say, look, you can't have oppression unless it's inconsistent with the business judgment rule. So it actually uses that as a reference point for determining whether or not conduct is oppressive. Okay, so did Frank's did it speak to the pleadings alone? Okay, so again, the Frank's case appeared to only be looking at the C10 motion and didn't extensively address the C8 motion, the pleadings requirements. It did suggest, it said they allege, so maybe we're talking about the pleadings requirements, in addition to providing evidence, the facts that the business decisions were improperly taken, and so on. And after making this statement, the court only wanted to discuss the facts and the evidence presented, which really went to the C10 motion, not the sufficiency of the pleadings. So arguably, the business judgment rule would still apply to a C8 motion, at least based on the Frank's case. And again, the MJC case that Professor Moll just referenced, the more recent case, suggested that a plaintiff's allegation that the defendants also engaged in shareholder oppression by refusing to declare dividends, despite their ability to do so, is further foreclosed by the business judgment rule. So and again, this was a failure to state a claim motion, and it was kicked. And again, the other claims that were involved here, being excluded from governance, claims in other capacities other than shareholders. So the business judgment rule did have teeth to the extent not only does the oppression statute provide for more limited avenues of, or in terms of the claims that can justify relief, as Professor Moll outlined in his lecture, To the extent that it narrows those grounds, the business judgment rule may have some teeth and provide some protection as well. That look, you're not even getting to the point where you're going to survive a C8 motion. I do want to point out there is some, again, there's not a ton of cases out there on this, right? So this stuff is developing. I did want to point out also, this is a pre-Franks case, but it's an LLC context. But in this, I believe Circuit Court, Oakland County Circuit Court opinion says that, look, a C8 motion involves factual determinations. It's not appropriate here. So we're not gonna deal with it. So again, this is pre-Franks. It doesn't, again, and pre sort of the elucidation and MJC as well. But I do want to point out there, I don't know that it's firmly settled what you have to do, at least with respect to oppression in the business judgment rule. But if MJC is right, if the reading of Franks is right, that it is relevant at the pleading stage, if you don't, please allege sufficient facts that would overcome the business judgment rule. So alleging the facts that those in control that are illegal, fraudulent, and the standards, again, that my colleague outlined, then the pleadings wouldn't survive. And again, maybe that doesn't mean much, right? We academics would get to worry about things that maybe they don't matter much because on the pleadings you're going to amend and you're going to refile. And maybe a good litigator is always able to satisfactorily plead oppression, right? I mean, if you've got, again, you got to have some facts, but if you have some facts, maybe you can spin it, right? And you would necessarily overcome the business judgment rule, and the business judgment rule doesn't do much work. And that may be true on the plaintiff side. I don't know. I'd love to hear from those of you, in the field doing this, talking about how you feel about that. I think where it may have more relevance is on the defense side, where the closer that a decision looks to an ordinary management decision, the business judgment rule in Michigan looks like another lever to pull or another reference point you should be hammering when making a C8 motion or the federal equivalent of the summary judgment. So it's not just that the facts pleaded aren't enough to show oppression, so you argue, but bear in mind that these facts must be sufficient to overcome the business judgment rule. Nothing pleaded shows that this was anything but an ordinary management decision. It was valuation. It was just whatever the decision was. The business judgment rule, this is well within the director's ambit, and it serves as an anchor or a frame of reference, and start there. And maybe again, that's possibly a way of framing it. Again, so when we're talking about dividends or at-will employment, again, these are possible strategies that can be used on the defense side. I'm very interested though on the claims pleading side, how all of you are framing in terms of how you are pleading, what you're thinking about. Are you thinking about having to address the business judgment rule up front, or are you just trying to make sure you're meeting statutory requirements for oppression? I'd love to hear what everybody is thinking about. Again, this is very much in its infancy, but I very much look forward to your questions. And this is a discussion. Again, this is an early stage project. Thanks very much. And I'm going to play my own music to get out of here. So I'm going to play some Beastie Boys and get out of here.
Thank you very much, Professor Zacks. We would like to open it up between Professor Mull and Professor Zacks to have a dialogue and speak back and forth if you would. We have 20 minutes for you two to engage in conversation. Thank you.
Okay, well, can I react, Eric, to some of the stuff you said?
Sure. Don't ask any tough questions, though. I'm used to be on the other side of that, so but go ahead.
Well, I'm trying to see, we also have some questions in the chat, but let me just say, first, my view is your project is very interesting because I will say personally, and I don't want to take up too much time because I would like to hear from some of the practitioners, I think pleading the business judgment rule and where is it pled and when does the court make the decision that that's going to apply or fairness is going to apply is a total mess. It's a mess to teach. I mean, I don't fully understand when you have to allege sufficient facts to get past the business judgment rule, and when does the court decide whether there has been a lousy decision-making process such that we're now going to get the entire fairness standard. I'm talking Delaware language here, but anyway, so I think that's great. And I will just say for my own personal purposes, the relationship between oppression and the business judgment rule is also a complete mess. And I just want to say 30 seconds on this and I'll stop talking. I have always assumed that if you are a plaintiff's attorney bringing an oppression claim and you're worried about, I agree with you, the defense should always raise employment at will, even though I don't think it technically applies, but I would raise it, and I would raise the business judgment rule. And I think the plaintiff has got to first address it just traditionally and say, I'm alleging bad faith. These guys are acting in bad faith towards my client, which is normally something that will rebut the business judgment rule. Or most oppression cases are just a conflict of interest. Normally the majority is freezing out the minority to sort of capture some of the income stream that would otherwise be going to the minority. When you have that, you can argue traditional conflicts of interest to get you past the business judgment rule. But I cannot emphasize this enough, and I will admit that this is just Doug Maul's personal opinion. The oppression doctrine is clearly displacing the business judgment rule, because the things the oppression doctrine is asking are not what the business judgment rule asks. And so maybe the easiest way to say it is, Massachusetts, they say, what's the legitimate business purpose? And then the minority gets a chance to say that legitimate business purpose could have been accomplished through a less harmful alternative. That kind of balancing, that's not the business judgment rule. The business judgment rule doesn't balance anything. The business judgment rule is, if you can articulate a legitimate, a rational business purpose for what you did, game over. We don't ask any questions like, was there a less harmful way to do it? And I think Michigan is similar. I think the Franks court actually got it right when they've got some sentence that says, look, if you can prove that you met that willfully unfair and oppressive definition, you have, by definition, overcome the business judgment rule. That is way more scrutiny than the business judgment rule would normally give. Anyway, let me stop talking there.
Just a quick reaction, then let's, I'm happy to open it up for, for others. I think that's probably right. I mean, I think if you plead it sufficiently, as you said, under the Franks, then you probably get there, right? But that, I guess maybe again, I'm interested to hear what the practitioners actually do, right? Is that what you're aiming to do? Like you bypass anything dealing with the business judgment rule in your pleadings because you're just going to allege enough stuff that'll get you to oppression. But if you're if you're defending the claim, that's when you may try to invoke business judgment rule. Like you said, that's what you would always do, because even if you, like you said, if it's irrelevant, it's irrelevant. It doesn't mean it's not a good point to raise, as and say it's a management decision.
Totally agree. And one more just 10-second point here. The fact that in Franks, they say that if you're on the defense side, you can raise a legitimate business purpose to rebut the element of you acted with the intent to, harm me as a shareholder. If you have to prove a legitimate business purpose, that is not the business judgment rule. Right. The business judgment rule, and again, I don't think this is a professorial argument, but maybe it is. But the business judgment rule is you don't have to prove anything. If the court can even come up with a rational business reason for you doing what you did, game over. In Michigan and in most oppression jurisdictions, you got to prove a legitimate business purpose. It can't be a pretext. You actually got to come forward with evidence and establish it. And in some jurisdictions, even if you establish it, the minority gets to say, yeah, but you could have accomplished that purpose in this much less harmful way. That is way beyond we are way past the business judgment rule when you're having to establish a legitimate business purpose and balance the minority's interests. So let me just say, I'll just throw out some questions that I see here in the chat. One of the questions was, does Franks make it easier to get summary judgment, I think? Yeah, does it increase the likelihood of summary disposition or decrease it? I've got my 2 cents worth, but Eric, do you want to?
Yeah, I mean, I think we sort of talked about it, right? I mean, if you're already, to the extent you think it's important because it does raise the specter of the business judgment rule, maybe it's useful because it just was used in MJC, right? It was invoked in MJC successfully, but maybe it would have come out that way anyway if you couldn't demonstrate what the statute already provides. right? So if the oppression statute stands on its own, and those quote that you talked about, it by proving oppression, you've already overcome the business judgment rule, and the business judgment rule is never relevant. You haven't changed much. But again, I'm speaking just to the business judgment rule, but I'm a more general question. I guess I'll let you
Yeah.
sort of jump in on.
Well, I guess I would just say, you know, if Frank's does require a motive inquiry, at least that's what I'm going to call it. I think it's really a motive inquiry. We're going to say, why did you do what you did? Was it to harm the interests of the shareholder or not? I think that's going to make it harder to get summary judgment because, at least generally, you know, motive is fact intensive. And so it seems like that's good for, well, I don't know. It's annoying for plaintiffs in that they're going to have to establish apparently this intent to harm the shareholder, but it would suggest to me that it's probably harder to get summary judgment.
Just a quick follow-up on that. Also, most of the cases that resist using the business judgment rule resist it for just that reason, right? You're talking about intent and motive and things like that, and things they don't want to kick it early, right? When there's facts to be developed on it. So that part of the resistance there is not, they just don't want to business judgment rule. And again, maybe that's what that other LLC case is sort of referring to. Is like there's a lot of stuff going on here that we have to determine why the board was doing what they did. It's not really appropriate to kick it on a C8 or C10.
Yeah, I think that's a great point. And let me just say somewhere also going on in here, and I'm not sure I can just sort of set up the problem, but I'm not sure I know how to solve the problem. The business judgment rule was largely designed for when you make a decision to benefit or not benefit the corporation. The business judgment rule was not really designed to deal with issues when you owe a duty to an individual shareholder, which is what oppression, particularly in Michigan, you owe duties to the shareholder, not just to the company, but to the shareholder. The business judgment rule fits pretty well when someone's making a decision of, look, I'm the majority and I get to steer this company where I want to. That's what it means to be the majority. And when the minority says, yeah, I wish you wouldn't steer the company that way, that should be a loser. That should not be an oppression claim. That should be a classic business judgment rule decision. But when the majority makes a decision that impacts the minority in a unique way, you fire me, you threw me off the board, you cut off my dividends, that's not the typical business judgment rule scenario. The business judgment rule analysis is designed for decisions that affect the company, not for decisions that are affecting individual shareholders. And so I've never fully understood how the business, like to me, as Professor Zacks said, I just wish courts would just acknowledge, almost like Frank's did, look, the business judgment rule doesn't apply to these oppression disputes. If you can meet the oppression standard, we have required you to satisfy a much higher hurdle than the business judgment rule ever would have required you to satisfy. So if you meet oppression, there is no business judgment rule. That to me is just a much quicker way of getting through all this.
Yeah, I think that's probably efficient. I guess, one point just to push back on, maybe it's not really a pushback, just in the cases sort of that I've come across with the business judgment, with the business judgment rule, the dividends is always hammered home as a principal board decision, well with, sort of a quintessential board decision. Now, I know it's ripe for abuse, but in terms of the cases, particularly Michigan that are out there, a lot of them deal with failures to pay a dividend, and you can't just say you should have paid a dividend, right? You have to go further than that. And why? Partly because it's a business judgment of the board, and that's who's supposed to be making distribution decisions. So
I agree. I agree. I think those dividend cases, when you're saying they are paying dividends and I'm not getting my share, they've disguised the dividends as employment compensation and I'm not getting my share, those cases are easy. Those should be winners. You can call those oppression, you can call them illegal dividend, you can call them conversion, you can call them a million things. But I agree with you, Eric, when the claim is, oh, we're not paying dividends, I just think as the minority shareholder that it's about time. That can be very difficult to win. And I agree with you that there is a specter of the business judgment rule in those kinds of cases. And let me ask you a different question, Eric, that's in the chat. Somebody mentioned, similar to the points we just made, the business judgment rule was developed in conjunction with derivative actions, doesn't seem to apply to direct actions for oppression. I think that's I kind of agree with that point. But maybe the question for you, Eric, that I think relates to pleadings, given that the assumption underlying the business judgment rule is that the court should defer, how is it even possible to resolve this issue before trial? So I guess the question is, if the business judgment rule is all based on the courts deferring, how is it possible to resolve this issue before trial? I'm not sure what this issue, maybe John can elaborate.
I think I probably just presumably the general claim. Well, if you haven't pleaded, for example, overcoming the business judgment rule, if you think about it just in a normal breach of fiduciary duty case, and maybe in this case, maybe he's going to your point, Doug, to say that in an oppression case, you've got to prove a certain state of mind or motive and things like that. And if you have to do that, how are you supposed to resolve that on the pleadings or beforehand? Maybe it's to that point, because obviously you could have business judgment rule does apply and does kick cases, even though there might be facts to be developed. But if you can't develop them before a certain amount of time, it's going to get kicked.
Yeah, and I should mention, and I think everybody gets this drift, right? Every state sort of articulates the business judgment rule in different ways. But if I was to try to boil it down, I think a fairly general encapsulation is there is a presumption. If you're challenging a board of director decision, presumptively you lose. That's sort of the effect of the business judgment rule. Presumptively, you're going to lose unless you as the plaintiff can displace the business judgment rule. And you can displace it if you allege in most jurisdictions bad faith, and that's a whole mess about what constitutes bad faith, a crummy decision-making process, or a conflict of interest. If you can allege one of those three, then you tend to either get a different standard of review, like entire fairness, which is a lot more scrutiny on the board's decision. But I guess, I guess the idea is I've always thought the way the business judgment rule can be used to resolve things on the pleadings is that if you don't come forward, if your only allegation in the petition is, I think the board made a stupid, dumb, unwise, whatever adjective you want to put in there, terrible, lousy decision. Like on the merits, that decision was bad. You don't allege a conflict. You don't allege bad faith. You don't allege a bad decision-making process. You just walk into court and say, I totally disagree with the decision the board made. To me, that should get thrown out on the pleadings. That business judgment rule should dispose of that, and there's no fact question to discuss. But anything beyond that, any allegations of bad faith or a conflict or a crummy process, or oppression, which I think kind of displaces all of that, gets you past the pleading stage.
Right. I agree. I just think there's some confusing overlap about when we talk about what constitutes oppression, right? There's similar things that would overcome the business judgment rule. And then are they mirror images of each other? And, I think we're still trying to sort that out based on the language of Frank's and some of these other cases that are out there. I want to make sure we're getting other.
Yeah, I agree. I think it's a good point. Let's see. We talked about that. I'm just looking at the chat. Given the assumption, yeah, okay, we talked about that. Yeah, so somebody asked, the business. So somewhere going on here, and I feel pretty confident that Professor Zacks is having the same thought that I'm about to say here, which is a lot of what we call oppression tends to overlap with what we would normally call breach of fiduciary duty that has nothing to do with oppression. In other words, I like to say it like this: Delaware does not have an oppression doctrine. They've got a Supreme Court case that explicitly says we're not coming up with any special rules for closely held corporation shareholders. And so someone asked in the chat, what would happen if, for example, the majority shareholder engaged in an interested transaction? They sold, they bought stuff from the company at below fair market. Why? Because the buyer was, a related company to the majority. You don't need oppression. You could bring that claim in Delaware and you would say that is a classic conflict of interest. The business judgment rule doesn't protect it. Entire fairness is the standard, and you'll fight about whether the price that was paid was fair. In Michigan, you could do the same thing, but you could also bring that as an oppression claim I've always sort of wondered what's the advantage to bringing it as an oppression claim? Well, number one is, particularly in Michigan, you get to avoid the derivative lawsuit. You need to meet any of the derivative lawsuit requirements because the statute appears to say you can bring in direct action, even if it's harm to the company. And the second thing that you all would know probably better than myself is a buyout. A buyout's not, if you're trying to get a buyout as a remedy for breach of fiduciary duty, there are some cases across the country that say that is an appropriate remedy, but not a lot. But in oppression, there's a billion. There's a billion cases that say a buyout is an appropriate remedy for oppression. So I've always thought that might be the second reason that it's advantageous to have an oppression action, even though it's the kind of thing you could bring derivatively, is because you don't have to fight the fight about getting a buyout.
Right, that's the hammer, right? Yeah.
I think in most cases. Someone points out that statute of limitations is different for oppression compared to derivative actions. So that's a good point. And I don't know the answer to this. In a lot of jurisdictions, it's very unclear what oppression is from a statute of limitations standpoint. So for example, I think that oppression is, quite frankly, just the flip side of breach of fiduciary duty to an individual shareholder. And so it should get the same statute of limitations as breach of fiduciary duty. There are jurisdictions that say, however, oppression doesn't have its own statute of limitations. It goes into the residual statute of limitations, which the jurisdiction will have some statute for, like everything else that we haven't specifically named gets this statute. I don't know. Do you all know here, is there case law that says what oppression statute of limitations is as if you bring the cause of action under the dissolution statute?
Sure.
The chat is suggesting that it is a different statute of limitations compared to fiduciary duty derivative actions. I don't know if that's true, but if it is, that's another good point. And attorney's fees, okay, you can get attorney. So that's interesting too. I mean, someone points out you can get attorney's fees in an oppression claim and not for breach of fiduciary duty. Now, that strikes me as odd. Is that a matter of case law in Michigan? Okay. For those of you, for whatever reason, don't care to look at the chat, the response is, per case law, the statute of limitations for oppression, okay, is the residual 6 years. Okay, so in Michigan, yeah, you get the residual statute. Okay, interesting. Well, any parting words, Professor Zacks?
No, I was hoping to actually hear from some of the practitioners in terms of how their pleading practices may have changed since since Frank's or some of the recent decisions. So maybe in some of the future chats or sessions, people might raise that. I'd be very interested to hear people's actual practices.
Well, I guess, thank you all very much. Thank you, Professor Zacks, for doing this with me. And maybe
Good to see you again.
Maybe we can do it again next year and we will all be physically in the same place.
A very special thank you to Professor Zacks and Professor Moll.